council, when we know that in terms of the provincial executive, the leader is the premier, and then we also have the MECs. And then in the legislature, it's also clear you have the speaker, you've got committees and all that. So basically what this section seeks to do is to make a clear distinction between the legislative and the executive arm within a municipality, and to also strengthen the role of the speaker, Honorable Chairperson. Then now we go to the next one, which is clause 18. This is the convention that I was referring to earlier, that it is convention or practice in municipalities that you have the troika, or you call the chief whip of a municipal council. However, this was not regulated. Now, in terms of the proposed amendment of section 41, then you would have section 41 capital A to F, which would deal with the following: how the whip will be elected, what will be the functions of the whip, the term of office, the vacation of office, how the whip should be removed from office, and also to have instances where there could be an acting whip. Presently, there is no provision that provides for the appointment or election of a whip in a council. So this one is also inserted to ensure that there's legal certainty. Then, Honorable Chairperson, we look at clause 20, which proposes the amendment of section 44, functions and powers of executive committees. Here, what we just need to indicate is that then there's an insertion of section 44, subsection 1b, that the committee of a municipal council which receives reports from the committees of the council referred to in section 80 must forward these reports together with the recommendations to the council when it cannot dispose of the matter in terms of the delegated powers. Here, in terms of the comment or the reasoning, is that the practice in some instances is that EXCOs and EM stifle reports of oversight committees. As they say, they must go to them first so that they can deal with the matters, and that they only need to take it to council if they deem it necessary. Then who will forward it, a report implicating themselves? So then now, in terms of this shortcoming, in terms of section 44, there is a proposal that this be dealt with to make sure that these reports are forwarded together with the recommendations to the municipal council. Honorable Chair, section 56 is also proposed that it be amended, and then we see that in clause 21. And then the proposal is as follows: that an executive mayor is entitled to receive reports from section 80 committees and to forward those reports together with a recommendation to the council when the matter cannot be disposed of by the executive mayor in terms of the executive mayor's delegated powers. Again, this is the issue of making sure that the council is given powers to deal with the matters of reports emanating from section 80 committees. Here, Honorable Chair, in terms of the rationale, is that experience has shown that reports from various committees are submitted directly to an executive mayor, and that this amendment will clarify that the executive mayor is only entitled to receive reports from section 80 committees, and that section 80 committees are the committees to assist EXCO or executive mayors in terms of section 80 subsection 1. This is just a diagram that illustrates how then these reports will be sent from the following committees reporting to EXCO. Then as you can see, Honorable Chairperson, you will see the section 79 committees, those reports go to council, and also section 80 committees reports, they go to EXCO or executive mayor and ultimately to council. Clause 22 proposes the amendment of section 73 of the Act, which deals with the establishment of ward committees, where municipalities must establish ward committees within 120 days after the election of all municipal councils. And then presently, there is no time frame for the establishment of ward committees in local and municipal and metropolitan municipalities. Hence, this one has been inserted, or is proposed that it be inserted, to ensure that there's understanding in all local and metropolitan municipalities. Obviously, there are circumstances where this may not be possible, and an example is given in terms of this case unless extenuating circumstances permit otherwise, such as the case of Ngutu, which happened during the 2016 local government elections. However, the date has been set that, or the time frame is 120 days after the municipal council or the elections, the election of all municipal council. Then the next clause 23 proposes the establishment of MPECs, then which are referred to as oversight committees, and there is an insertion here of section 79 capital A, which then will deal with the Municipal Public Accounts Committee. And briefly, Honorable Chair, just when we're looking at subsection 3, that the functions of the committee must include the following: the functions of MPEC: review of the AG's reports, review internal audit reports from the Management and Audit Committee, and also initiate and develop oversight report contemplated in the MFMA, and also attend to and make recommendations to the Municipal Council on any matter that would have been referred to it by the Municipal Council Executive Committee or Committee of Council. Then the critical issue is that the reports of this MPEC or of the committee must be submitted to the Speaker, who must table such reports in the next meeting of the Municipal Council. So here it's being clarified how MPEC should function, how those reports should be dealt with, and all of that, and ultimately considered by the Municipal Council. Then here the rationale is that the proposed amendment is to strengthen oversight and promote governance in municipalities. And then we'll also indicate here this amendment that councillors may be members of the committee and will provide for their roles and responsibilities. And what is very critical, Honorable Chairperson, is that the reports of MPEC must be submitted to the Speaker, who must table such reports in the next meeting of the Municipal Council. So the time frame within which the tabling should take place is now regulated by legislation. And then clause 24, almost now, slide 30, then it looks at or proposes the amendment of section 81, which deals with participation in municipal council by traditional leaders. Here, the proposal reads as follows: that when participating in the proceedings of a municipal council, a traditional leader is subject to the appropriate provisions of the Code of Conduct, which is set out in the schedule. And then also the reason for that, why is participation or the code of conduct that must govern traditional leaders when participating in municipal council is as follows: that due to the enactment of the Traditional and Cohesion Leadership Act of 2019, this clause is no longer relevant, and therefore the Department of Traditional Affairs has drafted proposed amendments to this clause for consideration by the Select Committee. This Select Committee then referred to Parliament, and then reference to the Systems Act is removed, as the Code of Conduct for Councillors is also migrated to the Systems Act into this very same act that there's a proposal that it be amended, the Structures Act. And Section 89, DMA, is also repealed due to the reasons that we have already mentioned by virtue of the repeal of Section 6. And then Clause 29 deals with Schedule 3, election of municipal office bearers, and then this item is to be amended in order also to include a whip as an office bearer, due to the reasons that we have already indicated above, that a whip now will also be regulated in the Structures Act. Honorable Chair, I've come to the end of the presentation, which is now Clause 32, which indicates that once the Act is passed and then it's signed into law by the President of the Republic, it will be referred to as the Local Government Municipal Structures Amendment Act of 2018. Thank you very much, Honorable Chairperson. That was the presentation from Legal Services.
Thank you very much, Advocate Mhluli. We'll now give Ms. Mkwebu to deal with the apologies.
Thank you, Chairperson. Chair, we've received an apology from the Office of the MEC for COGTA and the HOD. They were unable to join us due to other commitments. And then we've also received a lot of apologies from the municipalities, Chair, which I will not mention them one by one due to time, but we will note them in our minutes. But the challenges that they have, they thought we were on Zoom, others it's load shedding, so we humbly apologize about that. Those are the only apologies, Chair, that we had. But with the Department of COGTA, they've indicated that the Chief Director, Ubabu Magagula, which he was connected, and then Nomamule Tisbiya, they are part of the meeting, Chair. Those are the only apologies we received, Chair, and then most of the stakeholders will be submitting written responses, or written submission, should I say. Thank you, Chair.
Yes, thank you very much, Kwebu, for the apologies. And before I give the opportunity to our stakeholders, honorable members, can you please speak to the apologies?
Thank you, Chair. Move that we accept the apologies.
Thank you, Honorable Hlophe. Seconder. Honorable Morgan, are you still here? Honorable Tabete?
I'm still here. I'm still here, Chairperson. I will second.
Thank you very much.
I'm here, Chair.
Okay, no, thank you. Can we move to the next item, whereby we'll engage and give our stakeholders the opportunity to speak on the bill. Can I invite hands? Maybe let me start. Gertsi Bande, if you have something to say.
Okay, Chair, there's somebody that they've raised their hand. It's Councillor Mgomezulu of Salga. Honorable Chair.
Yes, thank you very much. Okay, we'll start with Honorable Mgomezulu representing Chief Albert Butuli and also Salga. You can start.
No, thank you very much, Chairperson. Greetings to yourself and all the honorable members, councillors and officials that are participating. Chair, on as Salga, maybe firstly we on the customary initiation bill, we wanted to take note of the bill, Chair, and we will make our submission, a written submission in due course. Chair, on the municipal structures amendment bill as proposed, we want to confirm that as Salga we've been participating throughout the processes since 2018, and we do support some of the amendments being proposed, but we want to make further comments, Chair. First, start with on definition. We do support the insertion, deletion, and substitution and insertion, Chair, but we wish to further make a proposal, Chair, on the definition of whips, that they be recognized same as at national and at provincial level, Chair, their appointments thereof. On section 2, subsection 6, paragraph A and 27 on district management areas, Chair, we support the deletion and all the references that are made thereof, Chair. On plenary municipalities, we also support the deletion, Chair, of section 7, C, 9E, 9F, and 10C. But we want to make a further proposal, Chair, to say such amendments upon signature of our President of the Republic should come into effect in the next local government elections. But also, Chair, that on plenary municipalities, we also do take note, Chair, On section 6, paragraph B and section 7, on MEC establishing municipalities, we oppose the deletion, Chair, of section 12.4a and section 16.3a for the following reasons. I'll only mention one, which is very important. The obligation on the MEC, Chair, as outlined in section 12, subsection 4, paragraph A, and section 16, subsection 3, paragraph A, is an integral part of the process, and if deleted, it will place the affected parties at a very serious disadvantage to engage and from an informed perspective with the MEC. Hence our opposal to that. On section A and B, section 8A and B, on number of councillors, we support the amendments as proposed, Chair. On section 9, cooling off period, we also support the proposed amendment. On section 10, election of councils, we also support the proposed amendment, Chair. On section 11, election of district councils, we also support the proposed amendment. On by-elections, which is section 12, we support the proposed amendment. On section 13, vacation of office, we also support the proposed amendment. On section 14, meetings of municipal councils, Chair, we opposed the amendment. If I may mention one reason, Chair. If the speaker or acting speaker refuses to call a meeting of council as requested in terms of section 1, the municipal manager of the municipality, or in the absence, a refusal by the municipal manager, a person designated by the MEC for local government in the province may designate a person to call and chair the meeting, Chair. On section 15, public notice of municipal council meetings, we support the proposed amendment. On quorums and decisions, which is section 16, we also support the proposed amendment. On type of plenary municipalities, again, Chair, we support the proposed amendment. On section 18, functions of speakers, we support the proposed amendment in principle, Chair, with the addition that speakers be allocated the following. They must ensure the effectiveness and functionality of ward committees, which for now is absent, it's silent. Also, the additions that the speakers must ensure the performance of ward councillors and ward committees, and as well, that is silent, Chair, which is a proposal to the functionality of that office of speaker to ensure the meaningful participation of traditional leaders in council. Chair, we on whips of municipal council, which is section 19, we support the proposed amendment in principle with the following amendments: that deletion of reference to more than 40 councillors should find expression in municipal councils. And also there must be a consideration of the addition as proposed under paragraph 1, Chair, of the definitions. On composition of executive committees, SALGA, we support the proposed amendment, and we also approve the insertion of the words which we noted, that an authorized representative to be inserted in clause D to read that, I quote, the political party or political interest to which seats are allocated to on the executive committee must be through an authorized representative. On functions and powers of ESCO, that is your section 21, we support the proposed amendment. On functions and powers of executive mayors, we support the proposed amendment. On establishment of ward committees, we support the proposed amendment with the following proposals for consideration, Chair. The insertion in subsection 1 should read as follows. If a metropolitan or local council is unable to establish a ward committee or ward committees in accordance with subsection 1, the speaker must, prior to the expiry of the 120 days after the elections, in writing and on good cause shown, request the MEC responsible for local government in the province consent for an extension, as well as the insertion in subsection 1B should read as follows. The MEC must respond to the request referred to in subsection 1A, which I have just alluded to, within 14 days, Chair, upon receipt detailing the reasons for granting or refusing the extension. So the deletion of the reference to the minister is supported, Chair. On establishment of Municipal Public Accounts Committee, we support the proposed amendments with the following proposals for consideration by the committee: that the nature, the statute, and authority of MPACs should be similar to the standing committees on public accounts, the ones that are established in national and provincial, the Scopus, Chair. On participation in municipal councillors, which is section 25, we support the amendment. On municipal demarcation board, we also support the amendment. On section 29 to 31, on schedule 1 and 2 amendments in particular, we support the proposed amendment. I think I will end here on behalf of SALGA, Chair in the province, but we wanted to confirm that we have been participating, and for now we have made additional proposals, Chair. Thank you very much for your time.
Thank you very much, Salka, for your inputs. Then now we'll allow Mr. Defo from Commission of Gender Equality.
Thank you very much, Chairperson. I will make an input on the Customary Initiation Bill. Greetings once more to honorable members of the committee, speakers of the municipalities, and all protocol observed. The Commission observed that initiation schools in South Africa are prone to perpetuate sexual and gender-based violence if stringent measures are not put in place to regulate them. It was reported in 2012 that 17 young girls were repeatedly raped and abused during a traditional initiation ritual in Mahushu on the border of Kruger National Park. The girls, it is alleged that they were assaulted physically and sexually, and there was an initiation stick that was used to beat them. So from the position of the Commission for Gender Equality is that we have a constitutional mandate to promote gender equality and human rights. And certainly the Commission has an interest in promoting openness, dignity, and equality, the founding values of the Constitution at initiation schools in South Africa. My input will be on 7 clauses. I will start with clause number 2.2, subsection 2. The intention of the bill, that is the objective of the bill. The intention of the bill is clear: to protect, to promote, and regulate initiation, to provide for the protection of life, the prevention of injuries, and the prevention of all forms of physical and mental abuse that initiates may be subjected to as a result of initiation practices. To address the governance aspect of initiation and the roles of all relevant role players. and to protect the customary practice of initiation and ensure that it is practiced within the constitutional and other legal prescripts. In view of the current wave of sexual abuse and violence in South Africa, we submit that the objectives should purposefully aim to also prevent sexual abuse. The failure of the bill to expressly recognize sexual abuse will not deter offenders from recognizing sexual abuse as a form of abuse, and thus will perpetuate the violation of young girls at the initiation school. Then the comment on clause 2.5. The Commission welcomes clause 2.5 of the bill that essentially bars any person to participate in any aspect of initiation if that person is unsuitable to work due to a conviction of a sexual offense. We submit that this clause will minimize initiates from being placed at risk of being sexually abused. Now, I'll move to clause 4 of the National Initiation Oversight Committee. We welcome the establishment of an oversight committee to ensure that the human rights are protected at the initiation schools. Moreover, the requirement that the committee requires 3 women is likely to ensure that gender equality is equally observed and respected at the schools. Clause 6, disqualification. We have noted that various grounds to disqualify a person from being part of the National Initiation Oversight Committee. Included is that the person has been convicted of an offense in respect of which he or she was sentenced to imprisonment for more than 12 months without an option of a fine. The reading on this ground suggests that a person who has been fined or served imprisoned for a period of less than 12 months may still qualify to be a member of the National Oversight Committee. We are concerned that this ground does not take cognizance of various sexual offenses and transgressions of a sexual nature, such as sexual harassment, that may not necessarily result in a conviction of a person to a period exceeding 12 months without an option of a fine. The Protection of Harassment Act, it defines sexual harassment very much clearly. And if one looks at the case of Motsamai and Everright building products, it was held that sexual harassment is the most heinous misconduct that plagues a workplace. Not only is it demeaning the victim, it undermines the dignity, the integrity, and the self-worth of the employee harassed. The harshness of the wrong is compounded when the person or the victim suffers it at the hands of their supervisor. So sexual harassment goes to the root of one's being and must therefore be viewed from the point of view of a victim. How does she or he perceive it, and whether or not the perception is reasonable? So it is against this backdrop that we submit that any transgression of a sexual nature should automatically disqualify a person from being a member of the National Initiation Oversight Committee. Then clause 9, we note that the duties of the National Initiation Oversight Committee, we submit that the awareness campaigns envisaged by this clause should include awareness of sexual orientation, gender identity, and sexual offenses. It must be emphasized that only female healthcare practitioners must perform rituals or practices to female initiates. We submit that this will promote gender rights of all initiates. Then clause 28, that is concern prohibition, age, and circumcision. We welcome that the bill states that no child or any other person may be forced to undergo virginity testing as part of the initiation process. We submit that the clause should read as follows. No child or any other person may be forced or coerced to undergo virginity testing as part of the initiation process. Clause 29, that is discipline and teaching. It is observed that the bill proposes that if an initiate is guilty of misconduct, the principal must, subject to the provisions of the section 28(7), take corrective steps in accordance with the custom of the community. We submit that the different customs in South Africa prescribe various corrective steps as part of discipline. This includes physical abuse. We submit that the acceptable standard prescribed by the bill should not promote violence, assault, including sexual abuse, no discrimination on the basis of gender or sex. So in conclusion, the Commission broadly supports the bill insofar as it pertains to the regulation of initiation schools. However, we are concerned, or we have concern about the bill's failure to focus on sexual abuse at initiation schools. It is submitted that stringent measures are required to curb sexual offenses at initiation schools, and the bill needs to prescribe these measures. We don't have any input or comment on the local government municipal structures amendment bill. Thank you very much.
Thank you very much, Mr. Tefo. Are there any inputs? Because I saw only 2 hands. If there's anyone, I can give you the opportunity to speak.
Yes, Chairperson. Good morning, Honorable Chairperson Masilela and other esteemed members. My name is Stubezi, and I am coming from an organization called SAULA, which is the South African Women Lawyers Association. As SAULA, we have noted both bills and have short comments to submit on both bills. Firstly, the Municipal Structures Amendment Bill, whereby we note that the passing of the bill into law will benefit local government, and it will give concise directives and restore accountability within and across local government. One of the things that we have noted would be the declaration of election of councillors and publication of their names. We feel that this ensures transparency to the public, particularly also to voters, in order to know the names of the people that they have voted for, and the fact that the declaration will be made on the said day. Secondly, we welcome the tabling of impact reports at sittings. This will ensure the necessary checks and balances, and it will ensure that matters that have been in the reports, that have been included in the reports, are dealt with speedily, as opposed to waiting a long time before such reports can be tabled. Therefore, when looking at the bill as a whole, we as SAULA welcome the bill. And then secondly, we have also considered the customary initiation bill. And as my previous colleague who just commented now stated, we have also noted with concern that there has been over the past few years a lot of unfortunate events emanating from initiations due to its unregulated nature. This cultural practice has become somewhat of a hazard, if you can put it that way, as certain health standards have not been met during the carrying out of the process. Therefore, as a result of this bill, SAULA welcomes it, as it prescribes rules and regulations to be followed. One thing to also note is that it criminalizes people who will divert from it as per Section 33 of the bill. We also welcome the involvement of various stakeholders and the creation of this oversight committee, because we feel that it will ensure strict compliance and accountability. And another thing that we have noted is that the involvement of government can perhaps mean that this will lead to an availability of resources or the employment of resources to assist and also to ensure safe conditions. It is indeed so that the bill has come as somewhat controversial, and it has raised eyebrows within particularly communities as they feel that perhaps it will infringe on people's rights to practice their cultures. However, we as SAULA have looked at it from another perspective and seen it as a means not to infringe, but to regulate for purposes of ensuring safety and also maybe for purposes of employing resources. Because in these committees, if there's reports, it means that at not just a national, but also at a provincial and also at a local level, there can be reports which indicate what resources are needed to ensure safety. So the involvement of medical practitioners also ensures that the procedures are carried out in a manner that will basically meet the safety standards. We have noted Chapter 4. Chapter 4 is particularly dealing with, firstly, the registration of such schools. It is dealing with consent, it is dealing with age, it is dealing with water, sanitation, food, healthcare standards, and we believe that this will make strides on what had become something that we have previously now indicated as being a potential hazard due to the number of deaths which one cannot turn a blind eye on in the past. So, for example, the bill indicates that no one can be forced to undergo this process on the issue of consent. Now, this means that consent will be a necessity, and failing which, one who is sent there without their consent, this will be criminalized. And also, when we look at the age, where it says no person under the age of 16 may undergo such process, and where it also prohibits virginity testing for people who are under the age of 16, we as SAULA, particularly as a woman organization, we welcome this. And in general, when we look at the bill as a whole, we feel that it will not come forth as an infringement of people's rights, but it will come forth as a way just to keep a check and balance, and also maybe, as we have indicated, as a means to employ resources or deploy resources and to assist these schools to do things in a manner that is safe. And I thank you.
Thank you very much, Fowler. Can we have Sodi links?
Thanks, Chair. We welcome the presentation on the bill itself. It is actually quite helpful. But of course, we also wanted to make comments from the environmental health point of view, where we indicated that the inclusion in terms of the definition, as I was going through the bill itself, I was actually looking at any definition in terms of environmental health practitioners, of which is not included, where we play a role in terms of environmental to ensure that there are no any other health nuisance that might emanate from the school itself. So there must be one environmental health practitioner that needs to do an inspection. And as we also go through the bill in terms of section 30, where it's talking about the issue of food, it is where we come in as environmental health practitioners to ensure that the food and the water that is being provided at the initiation school is up to standard and is actually fit for human consumption. So in these instances, I would like on the very same section of section 30 to ensure that there's a section where it speaks of the food and water being inspected by environmental health practitioner on the bill itself. Okay, thanks, Chair.
Thank you, Babu Soli. Chairperson is just disconnected. Challenge your network. Honorable Slope, can you assist? Honorable members are disconnected. Honorable Slope. May the Deputy Chair of Chairs assist, please. Thank you.
Yes.
All the honorable members are disconnected. It's only Honorable Trudy that is online. Honorable Morgan, can you assist?
I'm in line, Gugu.
Oh, okay. Honorable Tabete, my apologies. Honorable Tabete, please assist. But according to the hands, we don't have anyone as of now, unless maybe you ask from the floor if there are any inputs. Thank you, Chair.
Thank you. Greetings to all honorable members that are connected and our stakeholders and our support staff. Can I check, are there any further comments or addition, honorable members or stakeholders?
Thank you. Thank you, Honorable Chair. I just want to add on what my colleague here, Soli, indicated about the role of the environmental health people, obviously as officials. But my input is that which we will indeed just send it through as a submission to say the naming of the act. I think we acknowledge it, but we just want to know the relationship between this national legislation and the provincial legislation on this subject of traditional initiation schools. I think it was called Mpumalanga Ingoma Bill or something. We want to know the relationship between this act and the provincial that particular provincial act with the view of if you can consider saying this is a framework act that is overaching all the other acts all the other bills or acts in the provinces, and also cite that in the purpose or the objective of the act. Thank you.
Thank you, Mr. Is it Mahlang? I'm correct, Gugu.
Yes, Mami.
Okay. Are there any other member who wants to comment? Or we are fine? Can we go back to the legal team? Advocate Buyile.
Chairperson, this is Advocate Msweta. I made a presentation on cultural initiation bill. We welcome inputs and submissions made by our stakeholders, Chair. More importantly, on the Commission for Gender Equality, very pertinent and important submissions that were made. Chairperson would request that the Gender Commission can send those inputs so that we can be able to look at them and see whether they necessitate that we should propose for amendments into the legislation and see how far we can go with the legislation. But the submissions are very important, especially in terms of the sexual abuses and so on and so forth. To SAULA, the South African Lawyers Association, it was only a submission and they agreed in a lot of aspects that were there and they were commenting, Chair. So, but it will be also prudent that if they have any submission to make, they can give it to us. Of course, we'll look at the definition, environmental practitioners definition. We'll look at the biozone. We'll look at how can it be included and where is it covered and so on, and whether we can look at that. A very important submission that we can look at. But I think it's a comment about the food and on all of that. But because they belong, there's an oversight structure that looks at how initiation schools are dealing with, how initiation schools can operate. We'll see how all of those mechanisms, all those things can be looked at and have that relationship. The relationship between the Ingoma Act and National Act, remember that the province, all provinces, they can come up with a legislation in terms of the constitution, cultural legislation. So it belongs to a province. So this is, and so we've never had a national, this one speaks directly to the initiation schools. Whilst Ingoma would speak more into other cultural practices that happens within our province. But what we can do at the moment would be when we submit the report, we'll look at both the legislation. The Ingoma Act will look both the legislation and the national and the act to the National Act and see whether where are there similarities. However, as a province, we are able to be involved in cultural matters and to also legislate on cultural matters. So this is my submission would be, this is not a duplication of one of the other, but remember that all provinces, they've got their uniqueness in how they deal with these issues. And you have other provinces like your Gauteng that would not have that process or would have a different legislation. But we'll look at that. But this is a Section 76 legislation that comes from Parliament. And as a result, it's going to be an overarching framework that everybody would look at. But also remember, the Ingoma Act was done. There's an issue that this new legislation would be up to date and relevant in terms of the constitution, in terms of the relevant case law, and in terms of all of the laws that are there. So, but we'll look at both of them, and I know that after this legislation has been passed, there can be a need or that would request that necessitates that we go to our Ingoma Act and see whether we can amend it and see what we can do to realign with the national legislation. And it's a process that will come in the province for long. But also would request the submissions to be made so that when we come with a report and we deal with those reports and we deal with the negotiating mandate, then we are able to write it down and say, people of Mpumalanga are requesting this to happen, Remember, next week, all our honorable members and colleagues, there is a public hearing that must take place in other areas. But as it is, will be looking at it. But I will also maybe Advocate Mdluli would come also on one part of the Ingoma Act if there's any part that I've also not touched on. Thanks, Chair.
Thank you, Advocate. Then we'll allow Advocate Mdluli.
Chair, are you back? You must indicate that you are back because we were rescuing you.
Okay, no, sorry, Deputy Chair. Thank you very much.
Okay.
My apology.
Okay, thank you.
All right.
Okay, thank you, Honorable Chairperson. On the side of the Municipal Structures Amendment Bill, we have noted all the inputs and comments that have been made by our stakeholders here in attendance. We would not wish to respond to each and every matter here. However, we note all the proposals that have been made, and therefore we would like to indicate that we will consider them, because the next process that should happen now is that after the 14th, when the submission date has closed for the oral, or actually the written submissions, then the committee needs to meet and to come up with the negotiating mandate. I've noted, for example, that there's quite a lot of proposals that emanated from SALGA that we would have to consider. Now, what we normally do, the process that would have to unfold, we would have to take the bill and look at the proposals and to check the extent to which they are aligned to the other pieces of legislation, and then we will then advise the committee accordingly. But I must say that they're very critical inputs that were made, and we appreciate, and then we will deal with them when we're supposed to submit our negotiating mandate. And what is even critical is that the report for the negotiating mandate that would be going to the NCOP and ultimately the final mandate, it's a public document where then all the stakeholders that made their presentations today would be able to follow and to understand the extent to which all their proposals or the recommendations have been incorporated in the negotiating mandate that we'll be sending to the NCOP. But we really appreciate all the inputs that were made, Honorable Chairperson. When it comes to the issue of the customary initiation bill, I concur with Advocate Msweta that there are processes, or let me put it like this. There was once this piece of legislation, which now we have the TKLB, which is the Traditional Khoisan and Leadership Act. But we have what we call the Traditional Leadership and Governance Framework Act 41 of 2003. You would recall, Mr. Mahlangu, that we then had a situation where then provinces came up with their own legislation relating to regulating of traditional leadership. However, then this legislation that other provinces are having in place, they are not supposed to be inconsistent with the Constitution, and also not to be inconsistent with the Principal Act. So what happens here now, because we are having the Ingoma Act, which came into operation before the national legislation, which we are now considering, which once it's passed, the Customary Initiation Bill, it will be a national legislation. Therefore, then, as Advocate Msweta has indicated, there may be then a need to check the extent to which this provincial piece of legislation, the Ingoma Act that we are having as in Mpumalanga, the extent to which it responds or is aligned to the national legislation. Then should it be necessary, then there may be a need that this one of the province would have to be amended, but you will then see once the CIB Act comes into operation. That is what I can add. However, this also assists. We thank you also for that input, because going forward, these are the issues that we would have to take into account, including now just looking at the Ingoma Act currently. To what extent is it aligned to the Customary Initiation Bill, and particularly when it becomes legislation? From our side, Honorable Chairperson, we would like to say thank you very much from Legal Services, from all the stakeholders, And there was also an input from Saula, which we have noted. The other one, as I'm saying, that if we're not responding to each and every comment, is because we have noted those inputs, and then we will duly consider as the portfolio committee. I thank you, Honorable Chairperson.
Thank you, Advocate Ndluli, and our apology to our honorable members and our stakeholders. The problem of network, that's why we exchange each other to chair this meeting. Can you beam the agenda, Kuku? Kuku? Can you scroll up, sis? Where are we now, Kuku? Kuku?
Okay, sorry, Chair. We're dealing with the way forward now.
But
honorable members. Okay, honorable members and our stakeholders, I think Usisbuyi touched on it. Uguti, after the process that we've done now, we will have a negotiating mandate, which will finalize by the 15th, which will go to the NCOP as a report with all the proposals that were made today, Chair. We're still also going to be getting written submissions as well. Thank you, Honorable Tabete. And then we have the...
Okay. Thank you. I've heard that Advocate Buile was already summarizing the presentation, and also we request all the stakeholders who want to submit any addition or any comment, you are allowed to do so within the time frame. What is next, Kuku? It's vote of thanks. Let me take this opportunity and thank all honorable members from various municipalities and our stakeholders, our honorable members and our support staff. Thank you very much for your participation. I think this is going to assist our province to go forward and attend to each and every bill that arrived to our province. Thank you very much. The meetings then adjourned.
Thank you, Honorable Tabete.
Thank you, Chair. Thank you, Chair.
Thank you.
Bonga Mhlonishwa.
Siyabonga Sisi.
Bye. Bye-bye.
Bye.
Thank you, Cooks. We'll talk. Bye-bye.